back to Coffee with Coker. My name is Mark Reibold. I'm the host. This episode is actually our second espresso shot episode. If you're not familiar, normal episodes we call Coffee with Coker, but we have a number of kind of intermittent episodes that we call espresso shots, and these are designed. If you didn't listen to the kind of initial introduction of the first espresso shot episode, these are designed to be shorter, focus on a specific topic, and allow us to kind of drill down into some of the more specific or nuanced issues and topics that come up in some of the other discussions. So on this episode today, we're talking again with Jeffery Daigrepont, who is the Senior Vice President and leader over our healthcare IT consulting group. I would encourage everyone to go and listen to episode 6 of the podcast, where Jeffrey and I talk for the first time, and that's kind of a general overview of the healthcare IT market as it is today, and kind of the background there, and how we've come to where we are today, and kind of where it's going in the future. And then what we want to do was ultimately we're in a series talking about healthcare IT, and we're drilling down into some of these specific topics. The topic today I thought was really good. And Jeffrey had some great comments, but we're talking about the 5 fatal mistakes of an IT contract. And I know this is something that is definitely on the minds of whether it's a medical practice or a hospital. They're always dealing with various types of IT contracting discussions with vendors. And so Jeffrey does a lot of work in that area, and he has a lot of good perspective and good points and good takeaways. And so we were able to drill down into some of those pretty quick here. And then, I think it'll also lead to further discussion on this and other topics. So we hope you enjoy it. Real quick, I just want to encourage everyone listening to reach out to us, follow us. You can find us on Twitter at Coker Group. You can find us on LinkedIn. You can search for Coker Group and find our page there. You can also find more of our podcast content, and you can go directly to coffeewithcoker.com or just visit the Coker website, cokergroup.com, and you can find Coffee with Coker and the podcast there. And we really want to encourage listeners to provide feedback to us. So if you have suggestions on future topics, or if you have questions about anything we've talked about either here or in any other episode, feel free to contact us on all those social media places, but also you can email us directly, feedback@cokergroup.com, and we would love to get your suggestions and questions, and we absolutely will follow up with all those either on future episodes or future espresso shots, and we really look forward to talking to you all and engaging. Hope you enjoy this next episode with Jeffrey, and we look forward to hearing from you guys more. All right, well, welcome back to Coffee with Coker. We're back here with Jeffery Daigrepont, who runs our Health IT Consulting Group, talking again about healthcare IT and some of the things he does and is seeing working with clients. And actually, specifically today, we're going to have a quick discussion on the 5 fatal mistakes of an IT contract. So welcome back, Jeffrey.
Yeah, thanks, Mark.
If we're talking about the 5 fatal flaws of a contract, fatal, that seems like a strong word, or maybe a strong description. Talk about that and what's fatal about a contract.
Yeah, I promise you that's not clickbait title. That's
that's okay.
There really are some pretty risky things in contracts that we see frequently, and not to make light of it, but it's oftentimes said that this is a career defining or career limiting decision. And before I get too far into this topic, I do want to state at the onset that Coker has no financial conflicts, no financial relationships with vendors. We're completely independent and non-biased. We made that decision several years ago. It's obviously served us very well. I think when you are advising on system decisions or negotiating with vendors, it's extremely important that you are non-biased and free of any financial conflicts.
So when you're looking at a contract, you can honestly look our client in the eye and say, this is based on what you need now,
right.
what your situation is, your individual capabilities, constraints, need.
On a basic level, it's obviously a disservice to a client if you have those financial relationships. And I also think it's a disservice to the vendors, because vendors will not trust you And, in most instances, when we look at a contract, we are trying to figure out a way to make this a win-win for everyone. Now, let's be honest, contracts are never written to protect the buyer. They're always written to protect the seller. Even our own contracts are. So when you are the buyer, it's very helpful to have someone look at these very objectively.
Sure.
And as we go through this session, we'll give some examples of some of the key things that you need to look for.
Yeah. So you talked about how this is oftentimes a career defining, or maybe, that can be positive or negative. But what are some of the other kind of elements that you think fatal about or potentially fatal about a contract?
Yeah, the question I get asked a lot is, can we avoid these mistakes? And the short answer there is yes. The second question I'll usually get is, well, what if I already signed a contract? How do I go about modifying my contract? And so there's two ways we can approach this. One is vendors always have terms. So the contract will come to a point where you reach the end of the term. A lot of people just wait until it's time to renew. Then they will just simply say, I'd like to amend my contract or submit an addendum to address my concerns. And it may be that you've been with the vendor for so many years that your concerns are no longer as big as perhaps they would be with someone new. However, there are oftentimes things in contracts, even with the current vendor that you're happy with. Like, for example, many people do not know that almost every software contract is non-transferable. So think about that for a second. If you go to sell your practice and someone's doing due diligence, and that asset, that major asset, could not be transferred to the new owner, the value of your practice is going to diminish. Now, you might say, well, why would a vendor withhold that? Well, they may not, but they could come back in and say, we're going to charge the new owner. The licenses aren't transferred. What if you're selling the practice and you're not selling your AR? You're going to want to keep that system going, but maybe you want to let the new owner have the EMR part. So little things like that people don't think of, and that's where it becomes, I say fatal, but think of how devastating it would be to a physician trying to sell his or her practice to learn that their biggest asset is non-transferable.
Yeah, I mean, even in the smallest practice, you could have, an investment of $500,000, and sometimes in some of these systems, and that scale only goes up as you get into bigger deals. So you think about hospital consolidation and hospital mergers, you're talking about hundreds of millions of dollars. A large portion of that is attributed to their technology, and while they're made, oftentimes it's not just one single vendor or solution you're dealing with. You're dealing with multiple vendors, multiple solutions, multiple contracts over periods of time that you don't even know maybe what you're buying until you get it and you realize we got to pay for this thing again.
And you can have a cascading effect on these contracts. So now we find out it's not transferable. Then the second thing we find out is that the vendor can disable access upon termination. Sometimes, in fact, I would say about 80% of the contract says immediately upon termination, access is disabled. And here's the worst part: you must destroy or return the software. And again, if you think about that for a second, how many practices upon termination immediately are in a position to do that? You have a legal obligation to keep copies of those records. So people oftentimes just don't think about those things until they're confronted with it.
What about, modifying the contract? What do you think in terms of, some of the simple things that can be accomplished in terms of modification?
Yeah, so when we teach on this subject, and if you've ever attended one of my our Coffee with Coker webinars or even in-person seminar, we do talk on this a lot. So this is an area where we have a lot of expertise. And anytime I talk on this subject, I want to give you some very solid practical advice that you can do. Even though you've already signed a contract, vendors want to keep the relationship going. If you don't know how to approach the vendor, you're more than welcome to send us the contract. I'll look at it. I'll tell you specifically what's wrong with it and what you need to do to adjust it. So let's go ahead and talk just briefly about what these 5 critical mistakes are and exactly what you would do to address it. The first mistake that you would make or could make is that the software that you purchase is just not compliant. We see that a lot. Vendors are selling something. Your expectation is going to meet certain compliance standards. So I think it's very critical that the contract must state that the software that they give you is compliant. And be mindful that it may be compliant to a specific version. So some vendors have multiple versions, multiple products, and so make sure your version is the one that's compliant. And then the second mistake that goes hand in hand with that is not only compliant today, but it needs to be compliant into the future. So as regulations change, as new standards come up, that vendor, and by the way, if they don't maintain that compliance, then that either is a breach of contract that you would have no further obligation. And in some instances, we've even gotten vendors to make up the difference in the penalties. Let's say the noncompliance caused you not to participate in meaningful use, or you missed an incentive bonus. Is the vendor then responsible for paying that back to you? Number 3 kind of goes hand in hand with the first two, but you'd be surprised how many times vendors will sell software based on a term license. What that essentially means is at the end, you only have use of the software for that particular term, 5 years, 6 years, whatever. At the end of the term, it's over, and they come back to you and say, "Do you want to buy a new version or new term?" You need to make sure that you are allowed to have future upgrades, new versions. The term is as long as you're paying. Nowadays, it's subscription fees are popular. Inherent with every subscription fee should be future upgrades, support, new releases. But it's not uncommon. In fact, in the earlier podcast, the first one we did, I gave the example of Microsoft. Microsoft is the classic industry bully that comes out every 2 years with a new version of Windows, and every 2 years we start shoveling them more money. But you probably notice in recent years with the Microsoft 365 and their more modern hosted products, they too are trying to pivot to be more of a subscription-based product. The fourth mistake that a lot of folks make is, how do you address defects? There is not a single software platform on the market that I'm aware of that is 100% free of defects. They all have them. We know that going into it. The systems we have now are not perfect. The question is, how do defects get fixed? Who's responsible for correcting them? What happens if the defects cause harm to patients, which there's many examples of products being so defective that it's caused medical errors? Who's liable for that? How long? What's the workaround to fix them? What happens if the defects is preventing the practice from doing operations, seeing their patients? There could be all kinds of medical liability associated with them. So again, your defects is very, very critical. And fifth, and these are in no particular order, but I will say fifth is probably one of the most fatal, is not understanding what the termination requirements are. I'd be more than happy to look at anyone's contract, and I would bet over half the time I can show you where there's specific language that says upon termination, you must immediately discontinue use of the software. That is a major problem, and oftentimes gets people over the barrel where they're forced to either renew, extend their obligation. Let's say you've already made a decision to go with a new vendor, and you learn that your current vendor requires immediate shutdown of the system. Well, you might need another 6 months. Well, the vendor's not going to let you go more 6 months. They want you to go another 2 years. So understanding how you terminate, and along with understanding how you terminate, you must understand how you get your data back. Now, policymakers will tell you the data belongs to the physician and the patient. That's 100% true. But getting access to the data, the format you get it back in, what if they said, sure, I'll give you back your data. Here's a CD with all your PDFs on it. That doesn't do anything. You need an actual specific data criteria. An ASCII delimited format, for example, is an industry standard that allows you to move your data from one vendor to the other. The continuity of care records, another standard. The continuity of care documents, those kind of things. Another component of termination is your AR work down. Will you have time to burn off your old AR? You usually don't move AR from one system to the next. You might need a good 6 months to a year to work it down. And then the last thing that goes hand in hand with that is the actual migration itself, getting the data produced from one vendor, moving it to another. That means that you have to have the vendor who is replacing the vendor who you have work together. And we actually, while no one enters a contract wanting to terminate, we proactively stipulate how we will terminate.
Sure.
Everything down to working with the replacement vendor and cooperating. We specify the format we're going to get the data back. We specify how many months after termination we get ongoing access, look, view, print, whatever's needed. We specify how the retirement itself will take place. So that fifth area is very, very critical. Now, we could do this all day long. There's probably another 40, 50 modifications. Some are not as critical, like, for example, venue governing law, warranties, non-solicitation, cybersecurity. I actually kind of debated whether or not I should put cybersecurity. I guess if I was to add a 6, if you're going with a cloud vendor, who's responsible for data breaches? Every contract that I look at says the doctor is, even when they don't have control of the infrastructure. So here again, if that vendor gets attacked, you could be on the hook financially to pay for their cybersecurity breach. And that's going to be a fatal mistake, in my opinion. So those are the top ones. And again, I know we're going to get to this later, but you guys can give our information. But I will be more than happy. There's no cost. Send me the contract. We've seen them all. We're very familiar. I have binders in my office with these contracts already highlighted of where the problem areas are, and I'll quickly tell you what needs to be fixed and how to fix it.
Well, and I think that's interesting too. There's the legal perspective of looking at a contract, which of course you always need. But then there is some of these things they go beyond that kind of just basic legal perspective. Some of them, liability and data breaches and those things like that may tie in. But, just like within mergers, for instance, when we're doing a merger, particularly a hospital and physicians doing a deal, no one wants to talk about what happens if we need to separate or we need to do a divestiture or whatever. No one wants to think about that. But everybody will be thankful if it comes to that we outline how that is going to work in the event that we get to that point.
Yeah, that's actually a very good point. I'm glad you teed that up for me, Mark, because we are not attorneys, nor is our work should never be in lieu of getting your attorney to look at your contract. We actually complement the legal process because we focus in on the mechanics, the operational side of it, the business side, what are the expectations. Attorneys are really great at crafting language that's enforceable, T's and C's, looking at the structure of the document. Where we support that process is that we look at the operational side and make sure that the attorneys are fully knowledgeable. We also take advantage of having done this several times, so we get the advantage of kind of knowing what vendors have agreed to. Like, I give you a classic example. Most everyone always wants venue and governing law in their hometown. That basically means that if you have to take legal action, you get to have that legal action locally, not in the state of the vendor. Mm-hmm. Every vendor contract typically stipulates that not only venue, but governing law will be in their state. Well, first off, you try to move it to your state. But if that's not agreeable, a very common compromise that we see is that both parties can pick a state that's mutually inconvenient for both of them. Mm-hmm. Sometimes that's acceptable. Another compromise might be that if you go after the vendor, you'll go to their state. If they come after you, they have to go to your state. You could also both agree to arbitration ahead of time. So little things like that we'll point out that and attorneys are very good at making sure that you get those things. And of course, keep in mind, contract negotiations is kind of a process. There are what you like to have, and then there's what you're willing to compromise on. Some things I would always say don't compromise on. And then there are other things that are more or less like to have. I'll use the phrase frequently in my talks around, aim for the eagle, bag the pheasant, and hope you never have to eat crow on these things. And so it is a little bit of a process where you try to find common ground with your vendor. Yeah. And bear in mind that you have to show some flexibility. Hopefully it's the vendor does as well.
Well, it just made me think. Yeah, I had a car one time where, you pull down the little visor and it has those kind of warnings and everything. Right. And that one time I saw or noticed it said, "This car shall not be used as an ambulance." Right. Said, well, that seems kind of obvious. But then that's there because at some point, some joker was, thinking he could run an ambulance company out of his Cadillac or whatever. Right. I don't know. But the reason I say that is because even if some of these seem kind of obvious, they're there because of how many contracts you've seen, right. How often these things really do happen, right. And the fact that they can cost a lot of money, a lot of heartache, a lot of time and energy that could best be used elsewhere. So I guess the last thing I had though, I'm just curious. Say I'm a practice or I'm looking at a hospital CIO or something like that. I've already signed a contract. What can I do? Can I go back and do anything about it? And if so, walk me through that.
Yeah, after a podcast like this or even a webinar or seminar, the most frequent question I get asked is, I wish I had known this, sooner. I've already signed my contract. Does that mean that what can I do? There's two things you can do. I think one is you can certainly just say, call the vendor and say, look, we've had an audit, or I've attended a webinar. I've been given some guidance that these are proper things that should be in a contract. I should have gotten them done ahead of time. I'd like to submit an addendum. Usually the vendor's not overly excited about that, but at the same time, they realize that the relationship, having a long-standing relationship is worth it. If they're reasonable terms, they will usually consider it and grandfather them in or consider the request. Because remember, if they don't, that may provoke you to looking at other alternatives, or it may make you feel uncomfortable. Why would a vendor not agree to future upgrades if that's what they promised you? So all you're really asking is for this to be a little bit more equal in terms of it being fair and bidirectional. Second, if you get pushed back, I'm more than happy to take a call or even make a call. I cannot think of every now and then we'll get a vendor we never heard of, but the vast majority of vendors that are in the market, mainstream vendors, every one of these terms that I've described to you thus far, we have addressed it in their contract. So sometimes we can just call the vendor and say, would you grandfather in our standard terms and conditions, or let's take a look at this. And more times than not, they're willing to do it.
Yeah.
So it's one of those things where, you never know unless you ask. All they can say is no. But remember, if they say no, I would politely remind them that that's not going to be very favorable for them long term, because you're looking for a partner, not a vendor.
Well, I think, it's encouraging, honestly, because most people probably assume a contract is a contract. It can't be changed,
right.
or I am, completely restricted. But I think it's pretty encouraging to know that even if you're in a contract, there are options to at least solidify your terms and position in that.
Well, and I'll give you a great example. One of the things that vendors do all the time that is a little predatory, when they submit new orders, sometimes that resets the term of your contract. So you may, let's say you have an EMR, you're going to add patient portal. Well, patient portal could be set on another 5-year term that could actually retroactive your other term. So vendors are constantly coming back with new orders, addendums of their own, another module here. So they're asking you to agree to new terms, new obligations, new pricing. So it works both ways. The other thing, too, is that vendor A today may not have you may be perfectly comfortable, but that vendor could get acquired. They could merge. New leadership should come in. So it's always great to sort of future-proof your relationship, because we already established in the first podcast there's a lot of mergers going on.
Sure.
And so you never know if you may have a great relationship with the management team of your current vendor, but there's many instances where the vendor gets bought and
that can change quick.
Can change in a second.
Yeah. So I guess the moral of the story is let Jeffrey be the bad guy when it comes to the vendor.
Yeah.
Well, I mean, but seriously, I know you kind of have a process where you've been able to work with clients that is kind of starts with just free contract review process, and or maybe it's a call, like you said, and you can tee up an addendum or something like that.
Yeah, and in full transparency, I mean, I guess that almost everybody's always skeptical when they hear something that's free. We genuinely gain a lot and benefit a lot when we get asked to do this, because remember, if I have to get up and speak on this topic, consult on it, I really need to know what's going on in vendor contracts, and by having the opportunity and privilege to look at this now. If you said, can you negotiate it for me? Can you draft my addendum? Maybe I need some additional help. Can you negotiate these specific terms? Or maybe you go back and you try to get the contract negotiated yourself and the vendor's pushing back on you. Then that may require some actual us to be engaged. In fact, I will tell you, for compliance reasons, we would want you to be protected under our privacy statements and things of that nature. So, but the review of the contract is not hard, because you see so many of them. Chances are I've already encountered those same issues before, and we've already documented what the pathway to correct it is.
And kind of jump right in.
Yeah, we can just transfer that knowledge.
Yeah, that's great. All right, well, this has been really helpful, and those are some great tips. So I know you're out there speaking at conferences and clients and everything on covering these things more detail. And so, as we alluded to, there's going to be more of these follow-up discussions that we have on not just vendors and contracts and things like that, but, other kind of health IT trends. So we want everybody to kind of stay tuned, and we'll keep you posted as we talk more about this. And I know we'll see you back, but thanks, Jeffrey.
Yeah, thanks again. Always enjoy these, and it's always an honor and privilege. Everyone, have a good day.
Great.